We're
got
here
your
all
bad
day.
dad jokes here today.
I should have looked more up. I'm sorry. I didn't come prepared.
Well, you have all day to scour some more, maybe put them on
Don't make me
Facebook.
walk the plank, please.
Yeah, we won't. So the National Museum of Play in Rochester, New York unveiled the 12 finalists for induction into the Hall of Fame. So let's take a look at some of the inductees, or I think who they're considering. Battleship.
That's
You know
not
the
in
game
it
Battleship?
already?
Yeah, I know. I'm always
Wow.
surprised by the games that aren't in there. So this was originally a pencil and paper game. Did you know that?
I could see that.
Yeah, I did not know that, though. Battleship's inspiration began with strategy games in the late 19th century. Various manufacturers printed paper versions beginning in the 1930s.
Wow.
The iconic plastic came out in 1967, and since the debut, the game has sold more than 100 million copies. My daughter plays with her grandmother. They just played last week.
Oh, really?
Yeah, they love it.
I haven't played Battleship in years.
Same. Couldn't even tell you how to actually play it.
You just try to sink the
the ship, yeah. But
guess.
I cannot believe it's not already in.
That's odd.
That seems weird to
Well,
me.
congratulations, Battleship.
Yeah, well, 1998.
Okay.
I don't know that you would remember this toy. I do. Furby. You remember Furby?
I remember Furby.
Yeah, the fuzzy creature with piglet.
Could you identify yourself, please? Just wave your hand. Okay, thank you. Let's begin with the agenda. Mr. Jones, I know we just saw each other about 4 days ago. You told me about how you're doing. Give me an update, if you would, on how you're doing today. All right. How's the pain level?
Manageable.
Then at one time you got 6 out of 10, then it was an 8 or 9 out of 10.
Yeah, something like that.
Where are you today?
Probably like 5, like in
Good.
between.
It's going in the right direction.
Yeah.
You told me Monday that you are doing your own physical therapy. The doctors gave you some exercises and things to do to get better, right?
Yes, sir.
You're still doing that?
Yes, sir.
You also told me, I think it was your right foot was sort of floppy.
That's both feet.
Both feet? Getting some mobility back in those feet.
Not so far. I don't have them in these shoes, but in the other shoes, I have like an insert that goes into them that holds my calf.
Okay. That helping?
It helps me move around better.
Well, we got a ways to go with the recovery, it sounds like, but you're on the right track. We also talked Monday, and I want to talk about it today again. The medications you're taking, can you tell me today what what medications you're taking?
I don't exactly know all the names for them. I just know what their purpose would be for.
Okay, what are the purpose of the different drugs you take?
Pain meds, psych meds, and like stool softeners and stuff like that.
Are all of those medications helping you to, number one, control the pain, and number two, also help you to communicate with your attorneys when they come to see you, communicate with other members of the defense team who come to see you?
Yes, sir.
Okay. At any time have you taken these medications, whether alone or in combination? Because I'm guessing you're taking pain meds while you're also taking the psychiatric medication. Do they interact in a way so as to fog your mind or cloud your mind or affect your memory, anything like that?
No, sir.
Good. All right. I presume your lawyers have been coming to visit you regularly, correct?
Yes, sir.
They've been talking with you and giving you lots of information that the state has turned over to them. Is that correct?
Yes, sir.
You still trust them?
Yes.
Do you like them?
So far.
Sometimes they have to be the bearer of news that you probably don't want to hear. Other times, maybe not so much. So I can appreciate that. But I'm pleased to hear, and I've heard at each of these pre-trials that we've had together, that you're getting along well, you're able to communicate, they're able to communicate with you, they're coming to see you regularly. All that's correct?
Yes,
right?
sir.
And Mr. Klukas, I guess I'll ask you first, is all of what I just went through accurate with Mr.
It is. It is.
And you've been able to effectively communicate with your client?
We have. All three of us have been over to see sometimes collectively, sometimes individually. In those collective exercises, I don't think anybody has thought that there's a communication issue, and certainly in my individual interaction with Darnell, there has not been a communication issue.
Great. Ms. Baronis, let me ask you the same kind of question. I know you've gone over individually as well to see Mr. Jones.
That's
meet
correct,
with
Judge.
him, and you've had no problems with communication, have you?
No, Mr. Jones is always very interested in meeting with us. He's very polite. He provides us ongoing information and is able to, appears to understand everything that we're telling him and asks questions, and sometimes he comes prepared with a list of things he would like to know, and we do our very best to provide him the information he's asking for. Things are going very well as far as the relationship, I believe.
Okay, thank you. Last question, same question rather, for Ms. Eisenberg.
Your Honor, I would echo the sentiments of both of my co-counsel.
Okay. I might ask Ms. Baronis, I know that you've come to report to Pam occasionally the status of things. So since I asked Mr. Klukas the first question last time, I'll ask you, have you had any problems accessing the defendant and/or providing the defendant with discovery, whether digital, on a computer, paper, etc.?
No, I haven't, Judge. Every once in a while, if I ask for a very short appointment and I say if this can't be done and we could do it another time, then they'll give me another time. We're working it out. I mean, there's no issues with getting the opportunity to see Mr. Jones.
Good.
So that's all working out, and having to bring up whatever we need, computers or stacks of paper or whatever, I haven't had any issues with anybody at the jail making that work, even if it takes a little bit of time to get the appointment set.
Ditto, Mr. Klukas?
Ditto for me, and I wanted to add that we have not had any issue getting the appropriate experts in either. They've all been security cleared. The judge or the jail knows who they are, and we have not had any trouble getting experts in there either.
Great, thank you. Ms. Cox, since you're looking at me now, and Ms. Liptak was averting her gaze, can you tell me what the status of discovery is?
I did touch base with the FBI agent who's finalizing the CAST report. He indicates 30 days, if not sooner, that would be turned over to the state so that we can turn that over to defense. The state of Ohio met with investigators a few weeks ago, and we decided under a theory of best practices to submit just a few additional items to BCI for DNA testing and analysis. Those were submitted approximately 2 weeks ago. We were hoping to have those results back in about 4 weeks. There were additional hand-delivered items that were given to defense counsel today. Those are items that couldn't be uploaded into the Matrix case management system. Those were bait stamped, and we documented that those items were hand-delivered by a filing with the clerk's office today. There is one additional TPD report that was emailed to me yesterday that will go out in discovery, and then I believe we're just waiting one final TPD report.
So you expect 2 additional TPD reports to be coming your way?
One I already am in possession of. I just received it yesterday, so that will go out shortly. And then one I do not have.
The material that you handed over today, could you, in general terms, describe what that material is?
Yes, Judge, that is a compilation of criminal background checks for the defendant and witnesses in this case that under our contracts with Norris and various criminal institutions that were not allowed to upload into Matrix, so it was redacted with the appropriate redactions and delivered to defense counsel.
Any reciprocal discovery been turned over to the state?
Not yet. The state did file, when they responded to our initial discovery demand, they requested reciprocal discovery. Then I think last week they filed a new discovery demand, and I contacted the state and indicated to them that we would have an initial disclosure for them by the end of this month or the first week in October. did file a discovery response earlier this week indicating that as of the date of that response, we don't have anything to disclose. I did that to protect any potential speedy trial issue that may arise down the road. We certainly have things to disclose. And I had emailed the state and said, we'll have it to you here by the end of September, first week in October, and that's still on track. We'll have a disclosure, an initial disclosure anyways, by the end of this month or the first week in October.
Okay, thanks. I think there were some 911 calls when we were together last time with our status free trial.
Those have been sent out in discovery.
So with that ongoing exchange of discovery, granted, as I said, it's ongoing, but we had discussed before, and I think Mr. Previously would represent it to the court, that you would have some discovery motions in August. I know that seems to be delayed now, we're in September, and perhaps some search warrant motions coming yet by the end of this month.
Let me take those in order. We did file what I would characterize as one discovery-oriented motion already, which is referenced in the court's agenda for the Brady material. At this point, up till now anyways, some of the discovery motions that I would characterize as being standard in the battery of capital motions are not applicable primarily because of the amount of discovery we've received already. I don't know what the state knows, so I can't stand up and say they actually have given us everything, but we have been given a lot of material. And some of that material, even though we filed the Brady motion, I would characterize, at least in some respect, as Brady material. I don't want to file unnecessary motions. There's one more discovery motion coming next week. That may be it as far as the discovery motions go. I would expect, moving to the search warrant suppression motions, I would expect those probably to be into the court by the end of next week. Is that safe?
Yes.
Okay, yeah.
Okay, thank you.
I did want to add one other thing, though, that it's kind of a tale from our discussion in open court on Monday regarding the additional CSB motions. We have taken some affirmative steps to kind of cut through the Cuyahoga County red tape. I'm not promising that we'll be ready by next week, but it's pretty close. We'll have the motion for Cuyahoga County, and we'll have figured out the procedure for serving out-of-county subpoenas, hopefully by the end of next week, and we have identified a third county. There was some uncertainty on my part as to what that third county would be, but we have identified the third county, and we're taking steps, because it's also a county about the size of Toledo, maybe a little smaller, but there's some bureaucracy involved there too. So we're cutting through that. That motion for records I would expect to be in maybe 2 weeks.
All right, thanks. If you would, I think we may discuss this before. If you're requesting a hearing, please so note on the motion.
I'm sorry.
If you're requesting a hearing on any of these motions, or if your motion is simply for me to decide on the papers, just so.
Here, when the court made it to item number 7,
Okay.
and it says hearing requested,
Yeah.
and the answer is no, because we didn't request one. So we would always put, if we want a hearing, it'll be on the motion.
Okay. We had talked about, I believe, the last time, competency, NGRI, SMI, ID, all of those sorts of things. Can you tell me where the defense is? In
Sure.
terms of-
Well, I can in a general sense. So our mitigation specialists have generated a significant amount of records. And we have some other experts that are assisting us in the evaluation of that. We, all three of us, Ms. Eisenberg, Ms. I'm not exactly sure what we're going to do about that, if anything, right now. We are absolutely exploring the possibility of an SMI petition. The way the defense reads the statute, we only get one chance. We do not want to be hasty if we choose to exercise that. I would say maybe later in the fall, we could have something a little more definitive as to, number one, whether we're going to pursue that, and number two, when the filing that would initiate that proceeding would be in. I'm just not, other than it's being explored aggressively, I'm just not in a position to say anything.
We discussed Lorraine County records previously. Ms. Bronis?
Judge, in our research, we're at the point where we suspect there might not be a record, but it's my intention to request a transcript, which should clarify that. So we had talked about that when we last had a Team Darnell meeting, and that's just on the list of things to do, that I'll be requesting a transcript regarding the Lorraine County proceedings that should clarify.
There was filed by Mr. Daly on behalf of CSB a motion to quash. Mr. Lucas, I understand that from Pam that you wanted to address that in court today.
So I did, but in an exercise of fairness, I had emailed Mr. Daly at what turned out to be his old email address, indicating that we did not intend to respond in writing to the state's reply, but that I did want to have an opportunity to argue briefly. And the reason I said that yesterday is so that Mr. Daly could get, ready for an argument and get his client over here, and none of that happened, because my email bounced back to me saying it was undeliverable. Before the case was called this morning, I indicated to Mr. Daly that yes, I was ready to argue, but he didn't know, and if he wanted to set the matter for a brief argument next week, that is fine with us. Because I despite my best efforts, I didn't give him a heads up that I was showing up ready to argue today. So that's where that issue stands.
Your Honor, that's correct. I did provide Mr. Klukas my correct email address. When I left the county, they deactivated the email address and changed one letter. When it was reactivated, which caused this issue. My client, Lucas County Children's Services, is not here today because the anticipation was, well, we haven't received anything, we haven't heard anything, so therefore we don't think it's going to go forward today. On behalf of my client, I would ask that this be scheduled for next week. If there needs to be a hearing on it, and it does sound like that's the request.
Okay. And do you have a calendar up? Next Friday is unavailable for the court. Do you anticipate about a half hour?
Yeah, I believe I had indicated to Ms. Jagos that I wanted to argue briefly, and that's really what we want. So a half hour should be plenty.
I might suggest, if it gives both sides enough time, Wednesday, September 24th at the end of our docket. We usually wrap up our dockets on or before 2 o'clock. And we could make this at, say, 3 or 3:30 to provide plenty of time to...
One sec. I know that's good for me, but let me check with my colleagues. Okay. Okay, good for the defense. Ms. Eisenberg may not be able to make it, but as we have in the past, we'll talk to Mr. Jones and make sure he's okay to go with just the two of us.
You okay with that?
Yes, sir.
Thank you. Mr. Daly?
Your Honor, that works with my schedule. I will double check with legal manager at CSB. However, I'm sure if not her, someone will be available.
The docket is 2 full pages next week.
So if we say 3:30?
3:30?
Yeah, that's good.
Should be
Yeah.
safe to get everybody out from docket, get attorneys, defendants, et cetera, out,
Yeah.
allow you time to get in and set up.
That'd be fine. Yeah.
Wednesday, September 24th. representative who's present in court. You're here for that date and time. That'll be the next time that we'll have a mayor present in court. Any written response to the Brady motion, Ms. Latigue?
Not as of yet, Judge. We just received that, I believe. It was this week, and co-counsel and I have been in trial, so we'll have a response to that shortly.
Still in trial?
It ended last night, Judge.
There are some motions still pending before the court, and I know that we've talked about that before. And in terms of whether that affects your client's decision, Mr. Lucas, to execute a time waiver, how would you like to handle?
Here's how I'd like to handle this today, if it's okay with the court. We have motions pending that have not been decided, so we acknowledge time's been told. I don't know if at the end of this proceeding, the court intended to schedule another status pretrial, or if you wanted to defer that till after the argument on Wednesday. So for right now, we don't feel like we need to sign another time waiver right now. We know time is told, and if there's another pretrial scheduled at the conclusion of the hearing on Wednesday, then it would be our intention to sign a time waiver from that date to the scheduled pretrial.
Hold on to that until Wednesday then.
Yeah.
To clarify, there was a motion, defense motion number 6, and that was to issue a subpoena to produce records. Just so the records, you actually did issue that. We talked about that Monday.
We did.
And the state, through Mr. Daly, has responded. There was also a motion, I believe, captioned motion number 7 regarding expert assistance, which we, pursuant to Rule 42, discussed in camera, ex parte, in chamber, or on the record. And I just want to clarify that I don't believe that motion, let me ask, I'll put in the form of a question. Has that motion in your mind been ruled out?
No, it has not.
Because, as I
I mean, the court's certainly aware of everything, but I would not consider that motion to have been decided by the court.
The court would concur with that as well, based on the discussions we had with some more things coming to the defense attention.
Correct.
Okay, thank you.
I would add that I think also motion number 8 is also a tolling event as well.
Okay.
I mean, the state they said that they hadn't responded, they were going to respond, so to me, that's a pending motion as well. So we have several motions that I think certainly toll time till next Wednesday.
Sure. Well, and you have, as you mentioned, I'm expecting some more discovery motions next week, and the next couple of weeks, and the next few weeks. So,
Correct.
And there will be lots. Did you want to revisit bail? We've talked
No.
about it each time.
No.
Okay, good. Ms. Liptak, Ms. Cuck, are there any issues that the state wanted to bring to the court's attention?
No.
Mr. Klukas, Ms. Bronis, Ms. Eisenberg?
We're fine, Judge, thank you.
We'll see everybody then this Wednesday coming up, 24th of September at 3:30, specifically to your argument on the CSP's motion to quash, discuss time waiver at that time. And of course, if there's anything else that comes up between now and then, we can discuss that at that time as well.
Very well, thank you, Judge.
Thank you, everybody.
Oh, sure, no problem.
I just wanted to make sure. You know, I'm in all the courtrooms now, and if I don't want to go to a certain courtroom, I can hand off the CJE to someone and have other people sign it.